It's Nolan.
Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show.
I said I'm A-Town finest, so put my game down, grinding. Was on them Greyhounds trying to get out of state. My assignment was hit the stage at a college, encourage kids that could do it. Told them how to reach greatness, some days you must be secluded. On my own shit, hang up the phone shit, they on some clown shit. I'm David, I stay with a stone for cracking your dome with. Play me, I come to your home and ring your alarm. Bitch, I'm crazy, this ain't just a song. Quit raising your tone, prick. I'm that nigga, that number one spot, nobody can't top, I ain't even got dropped though. Big dog gon' run in my block, got the blade on chop, eat nigga like nacho. Rent do nigga sell like rock, move bass, I not do me like Rocco. Spend a bitch, she say I'm guapo. No money, I say no hablo, no English. My screenplay, try to get stretched out like Bengay. Don't call me, let you and your friend on the line, try to put it on three-way. I'm Green Bay, I'm about my cheese, nigga run up the check like relay. Got leeway, I flip my style like I'm a lucha libre.
What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everybody's doing well out there this evening. In this video, we're about to get back into the Megan Thee Stallion Milagro court docket, all right? I was just getting ready to conclude my day, and I got an email update that actually gave me the news that Megan Thee Stallion has filed new paperwork in the docket against Milagro Grrrls, okay? And this paperwork is a motion to reinstate jury verdict as to defamation claim, okay? Now remember, the jury found Milagro liable for defamation, right? But unfortunately, they also found Milagro as a media defendant, which ultimately negated the defamation claim as it pertained to the final judgment and also as it pertained to the actual amount of money that Milagro was on the hook for, right? So Megan is actually asking the judge to revisit that verdict and also to amend the final judgment or renewed motion for judgment as a matter of law and incorporated memorandum of law. Okay, so they're still pursuing defamation because once again, the jury did find that Milagro had defamed Megan Thee Stallion. However, there was a technicality because she was found as a media defendant and because Megan Thee Stallion never sent Milagro an official document of a warning, a cease and desist. Hey, please stop talking about me or I will be filing a legal claim against you. Because she did not receive that notice ahead of the lawsuit, that piece of the verdict ended up kind of working in Milagro's favor. Okay, so when she talks about new media, that's what she's talking about. When she talks about, there was no defamation, it's not true. However, she's not financially on the hook for defamation at this current time. Megan and her legal team are like, we need to check in about that once again. Okay? So without further ado, let's get into the paperwork because that's what's most important. All right, so here we have plaintiff's motion to reinstate jury verdict as to defamation claim and to amend final judgment or renewed motion for judgment as a matter of law and incorporated memorandum of law. Okay? So plaintiff Megan Pete, by and through her undersigned counsel and pursuant to federal rules of civil procedure 50B, 59E, and 60B, respectfully moves this court to reinstate the jury verdict as to plaintiff's defamation claim and to amend the final judgment consistent with the jury verdict and in support states as follows. Introduction. This case should have been tried and was rightly tried on the merits of plaintiff's defamation claim. At the pleading stage, the court properly decided a threshold and dispositive status issue that defendant is not a media defendant entitled to protection under Section 770.01. Now, if y'all remember, throughout the process of the litigation going back and forth before trial, through the discovery phase and all of that, reviewing Megan's complaint, reviewing Milagro's motion to dismiss, all of that good stuff, right? The judge did put in an order that said that she did not see Milagro as a media defendant. That was established. However, when it came to the jury, they decided differently, right? So they say, see order on motion to dismiss. That ruling, which was not challenged by defendant, governed subsequent proceedings. So they also point out that Milagro did not challenge that decision. The parties proceeded through discovery and trial preparation in reliance on that ruling. Under the law of the case doctrine, that legal determination governed later stages of this case, absent a recognized exception. Despite the fact that defendant never moved for reconsideration of that ruling, never moved for summary judgment on the basis that she was a media defendant entitled to pre-suit notice, never included this issue in the parties' joint pretrial stipulation, and never raised this issue at the October 30th, 2025 pretrial conference, defendant led the court astray at the November 10th, 2025 final pretrial conference and during the trial, and re-injected the rejected media defendant status defense into the trial. The court ultimately allowed the inclusion of several special interrogatories in the verdict form concerning defendant status as a media defendant, including one specifically asking whether defendant was a media defendant. The jury returned a verdict for plaintiff on defamation, but answered the interrogatory asking whether defendant was a media defendant in the affirmative. The court then entered a final judgment that did not include the jury's verdict as to plaintiff's defamation claim because the jury's conclusion that defendant was a media defendant precluded judgment for plaintiff on the defamation per se claim. This outcome impermissibly allowed defendant a second bite at the apple on a settled legal issue and should be corrected. Second bite at the apple. This motion does not seek to relitigate matters already properly decided, nor to present new evidence. Instead, plaintiff asked the court to correct a legal error that directly affected the outcome of this case. The submission and use of an ultimate status question that the court had already decided as a matter of law. Relief under Rules 50B, 59E, and 60B is warranted to correct this error and prevent manifest injustice. All right, so they're directly coming to task to basically press the judge on their decision, on her decision. Because they're saying here, you been said she wasn't a media defendant. However, when it came to the trial and when it came to the last pre-trial conference, all of a sudden this media defendant thing became relevant when you have already established she was not. And they say you established that as a matter of law. So how is it that at the end of the trial, we now have this media defendant question for the jury to decide on when it was already decided by the judge presiding over the case? They also say that many interrogatories were introduced into the court that should not have been permitted. So they're directly challenging the judge on her decision. I don't know if this is going to go as planned. Perhaps they have a contingency for if the judge denies this. I'm not saying that the judge will. I'm just saying I don't know how the judge is going to respond to this challenge. This is a very ballsy move right here. Got to be honest. Factual background. Defendant exhibits nothing that a media defendant would. She, 1, is not an objective, disinterested, or neutral reporter. 2, makes biased commentary intended to promote her business. 3, disclaims being a journalist and flouts its code of ethics as inapplicable to her. And 4, disseminates false and defamatory messages that misinform the public. These are definitely facts. Okay. A, defendant is neither neutral nor disinterested. She is a biased representative of Mr. Daystar Peterson, which the jury did align with and say that she was. Okay. Jury definitely said that she was moving in alignment with Tory. And of course, there was those deleted messages that were understood to favor Megan with the injunction and everything that needed to be, and the sanctions that needed to be relayed to the jury. So here it says defendant aligns with Mr. Peterson prior to his criminal trial. The evidence at trial and affirmed by the jury proves that defendant is not a disinterested reporter. Rather, she is a paid surrogate of the Peterson, Sunstar and Daystar Peterson, hired to promote their false narrative that plaintiff lied about being violently shot and to further smear her reputation by branding her as an alcoholic and mentally retarded, among other attacks. Mere months after Mr. Daystar Peterson shot plaintiff, defendant wasted no time aligning herself with him. Okay? They go to their exhibits from September 17, 2020, Instagram DMs with Tory Lanez. I don't know how you're doing your live tonight, but if you gave me that or any exclusive, it changed my life. Defendant September 2020, Instagram DM with Sunstar Peterson, who requested to speak with her off the record. By aligning herself with the Petersons, defendant aided Mr. Peterson's circumvention of the protective and gag orders that prevented him from speaking to or about plaintiff in relation to the criminal case. All right. He was placed under a gag order which said that he could not speak to or about Megan Thee Stallion. So he got in contact with Milagro. She took the mantle of harassing Megan and has been doing so ever since, right? Defendant willingly became Mr. Peterson's personal publicist and bullhorn, someone Mr. Peterson could rely on to publish his knowingly false and debunked narratives while maintaining a consistent line of attack against plaintiff. Defendant performed her services not as an impartial reporter or journalist seeking the truth, but as a paid surrogate compensated by her purported sources, quote unquote, to spread the company line to anyone who would listen. See Milagro Cooper trial, November 18th, 2025. So that's a transcript acknowledging Sunstar paid her $3,000 over the course of about 17 or so months, meaning that she received money directly from these people. Okay. Trial exhibit J261, defendant October 30th, 2024, live stream bragging about being on Daystar's quote unquote payroll and receiving birthday wishes from him. Okay. And remember, they're not presenting any new evidence. They're pulling from all of their exhibits, which have already been submitted to the courts. They're just reintroducing them to say, hey, there must be some oversight here. We've got 46-8, defendant text with Sunstar discussing Houston meetup. J353, defendant's text with Sunstar discussing a Miami meetup. So they meeting up in all these different places. She's getting money from them. She alluded to being on payroll and receiving birthday wishes. Not only that, but she was also shouted out in songs and stuff like that, where she was extremely flattered. Defendant's text with Sunstar discussing Los Angeles meetup. So Houston, Miami, LA. Sunstar Peterson deposition, November 20th, 2025, acknowledging that he paid for defendant's flight, hotel, and general travel and business expenses when she visited Miami. So these are multiple occasions in which Tory Lanez's father is meeting up with her, paying for her expenses, the whole nine. And the source of their meetup, or the source of their link up, directly falls in line with the Tory Lanez trial, where he was convicted of shooting Megan Thee Stallion. They didn't meet on some fluke shit. They didn't meet on some, oh, she's a great journalist. They met directly in tandem to go against Megan. Defendant proudly showcases her allegiance to Mr. Peterson during his criminal trial. Leading up to Mr. Peterson's criminal trial, defendant and Mr. Peterson's father coordinated a public relations campaign designed to obstruct justice and attack plaintiff's credibility. Defendant's flurry of texts with Mr. Sunstar Peterson reflects just that. See Trial Exhibit J335071. November 24th, 2022, text with Sunstar, who asked defendant to send him those materials ASAP to forward to attorneys. J19, defendant's November 25th, 2022 email to Sunstar with alleged dirt on plaintiff and attachments that may be of value. J353073, defendant's December 2nd, 2022 text to Sunstar with alleged dirt on plaintiff. J353075. Defendant's December 7th, 2022 text with Sunstar, who asked defendant to call him ASAP to discuss breaking news on a detective involved in Daystar's case. Defendant scoured the universe and dug up every dirt, whether true or false, on plaintiff. But that was not defendant's sole role. The Petersons knew that with every exclusive news they broke to defendant, she would take to social media to share with the mob. Trial Exhibit J353077, defendant's December 9th, 2022 text with Sunstar. Defendant attended every day of Mr. Peterson's criminal trial and sat with Mr. Peterson's family in the courtroom gallery, not with the media. Trial Exhibit J25, defendant's live stream claiming to be one of 4 women sitting on Mr. Peterson's side of the courtroom as family. Defendant also appeared at Mr. Sunstar Peterson's impromptu press conferences outside the courthouse, not as a reporter in the press asking questions, but rather as a proud quote-unquote daughter and sister standing alongside the Peterson family, making undeniably clear where her allegiance lied. See Trial Exhibit J21, December 23rd, 2022, Instagram post by the Shade Room showing defendant with the Petersons at a post-verdict press conference. Okay, one that she's bragged about ever since. So they're not only questioning the judge's decision, but they're also basically questioning the intelligence of the motherfucking jury. gotta be all the way clear here. Because they like all of this stuff was addressed at trial, but somehow overlooked. Even after Mr. Peterson sat in prison as a convicted felon for shooting plaintiff, defendant not only maintained contact with him, but crossed a line no disinterested reporter would. She flirted with Mr. Peterson, her purported information source. Instead of discussing legal strategies, alleged new evidence, investigative facts relating to Mr. Peterson's appeal, or even Mr. Peterson's music career or any other news, defendant and Mr. Peterson shared love notes, complimented one another's looks, and expressed mutual adoration. Whoa. I wasn't aware of that shit. I knew she had expressed attraction to his brother and said he could get it, which I found very strange. She been canoodling out here with his daddy, but I didn't know about no fucking love notes. Whoa. Unadmitted Trial Exhibit J383, defendant's June 2nd, 2024 Instagram DM with Mr. Peterson. Looking fine still, defendant. I know you in there charming whoever crosses your path. I love you. When plaintiff first sued defendant, she hired... Why would you say that to a nigga in jail? Charming whoever crossed your path. You know it's about he in there with niggas. I'm sure there may be some female COs or whatever, but come on, why would you say that? Anyway, when plaintiff first sued defendant, she hired the same law firm, Unite the People, that represents Mr. Peterson in his appeal. She did so despite recognizing that there might be a conflict of interest, also addressed at trial and completely schmoozed over. Milagro Cooper trial 14016 transcript. And did you talk about potential conflict of interest because they, Unite the People, also represented Tory? Her answer, I believe I brought that up. So she did acknowledge it. Caesar McDowell deposition trial transcript 2023, 21, 21, November 19, 2025, acknowledging that he recalls hearing that Mr. Peterson asked about a potential conflict of interest, but claiming to not remember why it would be a conflict. Okay? Because Caesar was the one actually assuring Tory that he had it covered. Then when addressed about it in deposition, he no longer could remember. See also Trial Exhibit J 433.311719. December 18, 2024 text with Sunstar discussing how to explain away $3,000 in payments. Sunstar, great, very good, but you should send it to the lawyers. I'm waiting to hear from Caesar, CEO of Unite the People. $3,000. He says you should send it to the lawyers. So not only is she associated with the family, giving them dirt, flirting with Tory, receiving money, but he's also advising her to how to spend her money that she's received from him for legal assistance, or at least how to explain the payment. B, defendant promotes her personal brand with biased, partial commentary favorable to Mr. Peterson. Defendant built her mob radio brand off of defaming plaintiff. Okay. We got a trial transcript, November 21st, 2025. She is famous because of talking about Megan Thee Stallion in the Tory Lanez case. She got famous and known for trashing me. That is a direct quote from Megan. Trial Exhibit J 486, defendant's June 9th, 2024 live stream. But I'm too influential now is what I've come to realize. Amel Holland Briggs, trial transcript, 2814 through 2914, November 20th. Testifying that defendant's dangerous cult-like following believes and further perpetuates anything defendant disseminates. It was almost a daily segment about plaintiff, to be honest with you. Defendant's obsessive coverage of plaintiff, particularly concerning plaintiff's private affairs, such as her family background, alleged mental capacity, or alcohol consumption, undercuts her argument that she operated for the purpose of informing the public on matters of public concern. Rather, defendant built a social media business centered around smearing plaintiff's reputation. Okay? Now, of course, Milagro's defense is that, hey, I talked about other trending topics going on in music and entertainment. However, the segments that were always popular, the segments that were always gaining traction and attention were the segments talking about Megan. Just being real. C, defendant conceded she is not a journalist. Defendant repeatedly admitted throughout trial that she has never been a journalist. She disclaimed any affiliation with traditional journalists or reporters and admitted that she never looked into the ethics required of journalists. Okay, Milagro Cooper, trial transcript, November 24th, 2025. Defendant does not believe that the journalistic code of ethics applies to her. She would only follow them if they were reworked to comply with her understanding of the way that the world works now. Milagro Cooper trial, November 25th, 2025. Defendant also made prior statements on her live stream disavowing any claims to be a journalist. So this is direct quotes here. At what point in time haven't I told you to go do your own independent research? At what point in time hasn't this show read that this is for entertainment purposes? At what point in time did you really think that I was getting up here and I told you I have a psychology and criminal justice degree? I ain't never told you I went to school for journalism. What fucking article did I write that I posted and said, y'all read this? What the fuck are y'all talking about? I don't think I'm anything, but I know I'm the person that gets under your skin. You don't need to be a journalist to see something and give an opinion about it. So my whole thing is, if I'm not trying to be a journalist and you know I'm not, what the fuck you mad about? Because I shouldn't be regarded as a news source any damn way. But you portray yourself as such. Defendant's October 30th, 2024 live stream. See also Milagro trial transcript, November 25th, 2025. In that same live stream, defendant again disclaimed any connection to being a journalist, claiming everything is not meant to be a news report. I did not tell anybody I was a reporter. Defendant instead characterizes herself as more of an entertainer. Indeed, defendant puts a disclaimer in every description box on all of her videos, claiming that her show is for entertainment purposes only and shall not be deemed as fact or advice. Okay? So they're fighting to classify her as simply an entertainer, not a journalist, not a media defendant, but an online entertainer that gets online to defame Megan Thee Stallion. Okay? Defendant instead, I already went through that, my bad. Defendant disseminates false and defamatory messages intended to misinform the public. There's no dispute that defendant is a prolific content creator. The evidence at trial demonstrated that defendant's content about plaintiff, which constituted the core of her online discussions, was false, biased, and defamatory. Defendant, no matter how regularly she released content, did not report on news or information related to matters of public concern. Instead, she was spreading rumors, speculation, and lies favoring Mr. Peterson and designed to obstruct justice in an effort to falsely exonerate him at the expense of plaintiff's reputation and emotional state. Indeed, every one of Tory's narratives that works in his favor has come from Milagro. They go to a February 23rd, 2022 X post saying, breaking. It was revealed in court a few moments ago that Tory Lanez DNA was not found on the weapon in the Megan Thee Stallion case. All right. November 20th, 2025. So Milagro tweeted this before court, and it's just what everybody still believes to this day. People still think that Tory did not shoot me because Milagro tweeted that his DNA was not on the gun, and that's not true. Okay. Trial Exhibit J299. From a July 30th, 2024 live stream claiming, I believe that the damn girl stepped on glass or a ricochet. Shit came and fucked up. Whatever you say happened, I don't believe you. So you got to work under the guise that I don't believe she got harmed that way. Milagro Cooper trial transcript 7135. November 18th, 2025, claiming she was merely posing a question by falsely claiming the gun and bullet fragments were missing. I don't know if y'all saw that, but it looked more like a statement than a question to me. Now, procedural background. The only time defendant raised the media defendant issue prior to trial was at the pleading stage in her motion to dismiss. The court disagreed with defendant and denied her motion on that ground. The court, relying on the well-pled facts, found that defendant lacked media status because she, 1, is a longtime mouthpiece for Daystar Peterson, plaintiff's assaulter, and his father's son star. 2, worked in concert with the Petersons to harass and discredit plaintiff on the Petersons' behalf. And 3, publicly admitted that she is not a journalist. I do find it very interesting here. Not only that the judge said these things, but the judge also granted an additional restraining order on Tory Lanez to say he could no longer collude with Milagro during the proceedings of the motion to dismiss and all of this stuff. So all of that is in line, but we'll continue. Worked in concert with the Petersons to harass and discredit plaintiff on Peterson's behalf. And 3, publicly admitted she is not a journalist. Defendant never moved for reconsideration of the court's ruling, nor did defendant move for summary judgment at all, let alone on the basis that she was a media defendant who would be entitled to pre-suit notice. At the October 30th, 2025 pretrial conference, defendant again chose not to raise the media defendant issue. It was only at the final pretrial conference on November 10th, 2025, after the close of pleadings, discovery, summary judgment, and prior pretrial conferences, that defendant re-raised the media defendant issue and requested leave to brief the issue on whether plaintiff was required to prove actual damages on her defamation claim. On the first day of trial, after the jury was seated and before opening statements commenced, the court again agreed with the plaintiff that the defendant does not qualify as a media defendant and found, consistent with my ruling in my order on the motion to dismiss, the defendant is not a media defendant. Interesting. Unlike at the pleading stage, the court based its ruling With the full benefit of the evidentiary record, it considered defendant's own statements made during her depositions, as well as her live streams disclaiming any characterization as a journalist. Damn. Nonetheless, on the fifth day of trial, after the defendant had testified, her counsel again sought to re-inject the twice rejected media defendant issue. After the party submitted briefing and met and conferred, the court held that the issue would be submitted to the jury subject to post-verdict briefing. Plaintiff then sought to preserve and raise the issue after the defendant's case in chief. Pursuant to Federal Rule of Civil Procedure 50, the court advised that plaintiff could reserve on the motion. Later that day, at the final charging conference, when jury instructions were being finalized, the court determined that the effects of the defendant's purported media defendant status were not for the jury to decide. In your proposed jury instructions that I reviewed, that you now have my edits on, I did not include that language. Regarding effects of media defendant status. Somebody did. I don't think that's a jury issue. What the effect of their finding is. Plaintiff clarified that the purpose of including language on potential consequences in the jury instructions was to clarify for the jurors that even if defendant was a media defendant, plaintiff would still be entitled to actual damages, which the court affirmed was a question of law and not a jury issue. Court, right, it's not a jury issue. The court then reiterated that it would address the consequences of a media defendant finding post-verdict. On November 26, 2025, the jury began deliberations. On December 1st, the jury rendered a unanimous verdict in plaintiff's favor on all three of her claims. 1, defamation per se. 2, intentional infliction of emotional distress. And 3, promotion of an altered sexual depiction. Specifically with regard to plaintiff's defamation per se claim, the jury found that 1, defendant defamed plaintiff, and 2, such defamation caused plaintiff actual damages. The jury also found that defendant did not provide disinterested and neutral commentary rather than advocacy for a particular client or personal interest, and did not impartially disseminate information, but rather acted primarily to promote her own business, products, or services. Despite finding that defendant failed to provide disinterested, neutral, and impartial commentary and used her platform for her own business interests, the jury determined that defendant qualified as a media defendant. That was extremely baffling to me when I read it. Throughout deliberations, the jury had expressed confusion as to how to properly evaluate the media defendant factors. Okay? Says here, this is a quote from the jury. "We are confused. If we believe half of the factors, is that considered a yes as to defendant's media status?" In response, plaintiff sought to advise the jury that while no one factor is dispositive, whether a defendant is disinterested and neutral, answer to question 3 of the verdict form, is the most important factor under this circuit's precedents. Plaintiff's counsel, December 1st, plaintiff also sought to advise the jury that answering yes to a majority of questions 3 through 7 does not mean that you must answer yes to question 8, that defendant is a media defendant, and vice versa. Defendant, while agreeing that no one factor is outcome determinative, argued that a finding for half of the factors would mean defendant qualifies as a media defendant. Defendant's counsel, the court ultimately instructed the jury simply that there is no set number. The jury, as such, did not receive further guidance as to which specific factors should be given greater weight than others. Thereafter, the court entered final judgment on counts 2 and 3, but not on count 1. Okay? And defamation was the primary count. So now we get into legal standard. Okay? Pursuant to Federal Rule of Civil Procedure 59E, a party may seek to alter or amend a judgment if a motion is filed within 28 days after entry of the judgment. The court may grant a Rule 59E motion to correct clear error of law or fact or to prevent manifest injustice. Okay, so you have to file this within 28 days after the entry of a judgment, so they are within their time period. Okay, similarly, Federal Rule of Civil Procedure 60B provides that a court may grant a post-judgment motion under certain circumstances. 1, a mistake, inadvertent, surprise, or excusable neglect. 2, newly discovered evidence that with reasonable diligence could not have been discovered in time to move for a new trial under Rule 59B. They're not saying anything about new evidence. 3, fraud, whether previously called intrinsic or extrinsic, misrepresentation or misconduct by any opposing party. 4, the judgment is void. 5, the judgment has been satisfied, released, or discharged. It is based on an earlier judgment that has been reversed or vacated, or applying it prospectively is no longer equitable. Or 6, any other reason that justifies relief. Federal Rule of Civil Procedure 60B, a mistake, as contemplated by Rule 60B1, encompasses a judge's error of law and applies to misconception, misunderstanding, or fault in opinion or judgment. A mistake also encompasses the ordinary legal meaning to include a judge's mistakes of law or fact. Similarly, a Rule 59E motion gives a district court the chance to rectify its own mistakes in the period immediately following its decision. This shit interesting, man. You know, I'm not a legal professional, but 2024 and 25 have been like crash courses in fucking entertainment law, I must say. Now we're getting a situation where Megan is directly challenging the judge and jury's decision legally with legal recourse, not like how some niggas been coming out and using the press to question things, going to TMZ with questions. Y'all know what I'm talking about, or you should. They're doing this in the docket. Rule 60B6 is the catch-all ground for relief and allows for relief for any other reason that justifies relief. Rule 60B6 is available when there is a risk of injustice to the parties or a risk of undermining the public's confidence in the judicial process. The decision to grant a Rule 59E or 60B motion is committed to the district court's sound discretion. Lastly, under Federal Rule of Civil Procedure 50B, a movement may file a renewed motion for judgment as a matter of law after trial. The standard for granting a renewed motion for judgment as a matter of law under Rule 50B is precisely the same as the standard for granting the pre-submission motion under Rule 50A. Thus, as with motions under Rule 50A, the question for the district court confronting a renewed Rule 50B motion is whether the evidence is legally sufficient to find for the party on that issue. Stated differently, entry of judgment as a matter of law under Rule 50B is appropriate when a party presents no legally sufficient evidentiary basis for a reasonable jury to find for him on a material element of his cause of action. 2. The motion to dismiss order decided the controlling legal issue and became the law of the case for trial and post-trial proceedings. All right? So now they go to how the judge's motion to dismiss order was legally binding, which found Milagro as not being a media defendant. The well-established law of the case doctrine prohibits the relitigation of legal issues previously decided in the same case. This policy ensures that there will be an end to litigation by foreclosing the possibility of repeatedly litigating an issue already decided. When a court decides upon a rule of law, that decision should continue to govern the same issues in subsequent stages in the same case. Internal quotation marks omitted. This doctrine is designed to further important goals vital to just and efficient judicial process, including the provision of an end to litigation, the discouragement of panel shopping, and the promotion of consistency in rulings between courts. The motion to dismiss order did more than merely allow this case to proceed. It resolved a discrete legal question essential to liability, whether defendant is a media defendant entitled to statutory pre-suit notice under Florida Statute 770-01, which the court clearly and unequivocally decided defendant was not. Had the court determined otherwise, count 1 of plaintiff's complaint would have been dismissed. So they're saying if the media defendant piece was actually valid, then Milagro's motion to dismiss on count 1 would have already went through prior to trial. Damn. I remember going through this stuff. I remember reading this stuff. So they're using the judge's words against her ass. Let me get back to this. Had the court determined otherwise, would have been dismissing defamation claim due to insufficient pre-suit notice, stating ordinarily a plaintiff's failure to comply with the pre-notice requirement requires dismissal of the complaint for failure to state a cause of action. Denying motion to dismiss, finding defendant is not immediate defendant entitled to pre-suit notice. Had count 1 been dismissed for this reason, plaintiff could have and would have provided pre-suit notice in order to cure this defect in its pleading and thereafter refiled its defamation claim. If the time to comply with the statutory precondition has expired, should the action be dismissed with prejudice. However, the court's correct determination that defendant was not immediate defendant obviated the need for any pre-suit notice. Why would I give you pre-suit notice if you aren't media? Which the judge established. No exception authorizes a departure from the motion to dismiss order. Clay identifies 3 narrow exceptions. 1, substantially different evidence. 2, intervening change in controlling law. Or 3, clear error in the prior ruling producing a manifest injustice. Defendant presented no new substantially different evidence bearing on her status that would justify relitigation of the threshold condition precedent question. There was no intervening change in controlling law, and the only manifest injustice here would be the nullification of the merits verdict based on a pre-suit notice requirement the court already held inapplicable. Now, here's where I gotta hold Megan's legal team, John O'Sullivan, I believe, to be exact, accountable. If y'all can recall, and I think everybody that was in the courtroom that actually saw this happen spoke about it, and they had raised eyebrows. Y'all remember when John O'Sullivan was having a conversation with Milagro about that whole media thing and what is new media, and if new media is to be a thing, what should be the rules for new media? What is your understanding of media? I think he did a fucking disservice at trial by holding that conversation with Milagro on the stand. And the reason why I say that, and this is just my personal opinion, but it's backed by other people who were in the room, is that introducing this new media concept in front of the jury and allowing her to actually outline what new media would look like, I think that actually gave them the idea that, oh, maybe she is media, right? If they're having this whole new media discussion, because basically new media, it's a term that actually pre-existed Milagro's usage of it, but it's basically rewriting the rules of what media is in real time, right? Draymond Green is a big advocate of new media. He's an active NBA player that has a podcast outside of the NBA talking about what's going on in the NBA. He was one of the first people to do it. Others have followed. And that was one of the concepts of new media. Like, wow, an active player is actually actively talking about what's going on in real time during the course of the season. And a lot of teams that have players that do this shit, they don't like that shit. They like, keep your motherfucking head in the game, right? So if you're a proponent of new media and an attorney or a lawyer is standing in front of you asking you, well, if new media is a thing, how do we determine what it is? And they allow you to answer it and give guidance on what new media is supposed to look like, the jury might say, okay, well, maybe I need to keep an open mind about the concept of new media. And this person that's on the stand is saying that they're new media. So maybe I shouldn't hold them to the standard of traditional media because this person is new media, but media nonetheless. And having those conversations, and clearly the jury was fucking confused because they said it on paper. I think that influenced a lot of what we're seeing today that they're now trying to clean up on the back end because they fucking let Megan down. I'm gonna be clear about that. I'm gonna be honest. They let her down. So now they're trying to do cleanup work after the fact. Anyway, they say defendant presented no new, substantially different evidence bearing on the status, blah, blah, blah. Substantially different threshold condition precedent question. There was no intervening change in controlling law, and the only manifest injustice here would be the nullification of the merits verdict based on a pre-suit notice requiring the court already held inapplicable. Indeed, the purpose of Florida Statute 770-01 is to afford newspapers and periodicals an opportunity to make full retraction in order to correct inadvertent errors and mitigate damages, as well as to save them the expense of answering to an unfounded suit for libel. Okay? So Florida Statute 770-01 is afforded to newspapers and periodicals for making incorrect statements. They can retract and move forward. We've seen no such thing from Milagro of retracting anything. She's still standing on what she said, how she felt, the whole nine. Even after losing, she still stands on everything she said and is doing interviews continuing to stand on it. That's not how retraction works. In other words, it was never the intent of the Florida legislature to have parties in a defamation action proceed all the way through trial, only to strike a defamation claim for failure to provide pre-suit notice. Three, defendant waived and forfeited any attempt to re-inject the statutory notice issue at trial and is equitably stopped from using it post-verdict. Even apart from the law of the case, defendant's attempt to resurrect the statutory pre-suit notice issue after litigation and losing it on the motion to dismiss, declining to seek reconsideration or interlocutory review, and then trying the case on the merits was waived, forfeited, and barred by fundamental fairness. Plaintiff reasonably relied on the court's motion to dismiss order and defendant's silence in shaping discovery, trial preparation, and the presentation of evidence. Defendant never preserved this issue in the joint pretrial statement and never raised it at the October 30th, 2025 pretrial conference, only to spring it on plaintiff at the final November 10th, 2025 pretrial conference and trial as an end run around the jury's ultimate decision in favor of plaintiff on her defamation claim. Florida's equitable estoppel doctrine exists to prevent exactly this sort of sandbagging. A party may not lull its opponent into a strategic and legal posture and then take an inconsistent position that inflicts substantial prejudice. Explaining that the doctrine is applicable in all cases where one by word, act, or conduct willfully caused another to believe in the existence of a certain state of things and thereby induces him to act on this belief injuriously to himself. Permitting defendant to do so here would not only reward gamesmanship, it would also risk converting defendant's belated maneuver into a limitations trap that wipes out plaintiff's defamation claim entirely. Equity does not tolerate this result. 4. The media defendant special interrogatory was improper. A special interrogatory cannot be used to override the court's controlling legal determinations. Here did just that, override the court's determination as a matter of law that defendant is not a media defendant. Because again, the judge's motion to dismiss stated, or response, an order on the motion to dismiss stated, Milagro was not media. The media defendant classification under Florida Statute 770-01 involves a similar court-centric inquiry as the court's determination of a defamation plaintiff's status as a public figure. The inquiry may involve the examination of facts, but the designation is ultimately reserved for the courts. Critically, Florida courts describe the analysis itself in court-centric terms. To determine limited public figure status, for example, the court must determine whether a public controversy exists and whether the plaintiff played a sufficiently central role. That is, while the process may require evaluating the record, it is the court's job to bestow the legal label public figure versus private figure. Likewise, courts have framed the media defendant question in court-centric terms, applying clear legal standards to determine whether a defendant should be classified as such. Relatedly, courts routinely decide whether a defendant is a media defendant as a matter of law at both the motion to dismiss and summary judgment stages of a case. I'm going to skip some of this stuff in parentheses. Here, too, the court determined as a matter of law that defendant was not a media defendant at the motion to dismiss stage. Public figure status allocates constitutional fault burdens, whether actual malice applies, and shapes what must be proven to impose liability. So the court describes this status designation to ensure uniform, legally correct application. Similarly, media defendant status allocates statutory pre-suit protections and operates as a dispositive condition precedent, so the court likewise decides the status designation to ensure uniform, legally correct application of Florida Statute 770.01's reach. Collecting cases and describing how courts construe the statute's application to a news media defendant. In other words, both labels are status determinations with major legal consequences. They may depend on underlying facts, but the ultimate classification is the court's responsibility. Thus, while the court may arguably submit narrow factual questions about predicate facts to the jury, which plaintiff contends were erroneous nonetheless under the law of the case doctrine, the ultimate legal determination whether the defendant is a media defendant for Florida Statute 770.01 purposes remains for the court to decide as a matter of law. A special interrogatory asking the jury this ultimate status determination improperly transferred the court's gatekeeping role to the jury. Moreover, the pre-suit notice required under Florida Statute 770.01, if even applicable, is a prerequisite to suit. It is a threshold question that must be resolved before the case proceeds. It is not an issue to be tried after the parties have fully litigated the merits through trial. Accordingly, the court should treat the media defendant interrogatory answer together with the other related special interrogatories as immaterial and or strike them. So basically what they're saying is this Florida Statute 770.01 is not something that should be determined at trial. And it wasn't determined at trial because the judge had already said she wasn't media. Right? And it's supposed to apply pre-trial because, again, it's about pre-suit notice. So had Milagro been determined as a media defendant, they said that would have given them the opportunity to retract their complaint, give her notice, and refile for defamation at a later time. And again, the judge said she ain't media. So here, defendant is not a media defendant. We're going to keep going through this. The jury found that the defendant, despite advocating for a particular client or personal interest and acting primarily to promote her own business, products, or services, should be treated as a media defendant. But no court has ever extended media defendant status to a defendant who supplies and receives information to affect criminal proceedings while maintaining a paid and intimate relationship with the accused. This court should not be the first. And I think this is actually a very key point. I've been wanting to get to this. You know, Megan Cuniff, she gets a lot of flack. People love to say that Megan Cuniff is so biased. Oh, she's biased, right? Milagro has even said that. But we've seen no instance of Megan Cuniff receiving payments from niggas out on trial. We ain't never seen Megan Cuniff going from city to city, state to state, hanging out with niggas that's on trial. Even when she seen Megan Thee Stallion coming out the courtroom each day, she was nervous to even ask her fucking questions. And rightfully so. And Megan Cuniff has been depicted in multiple videos. Once in Tory Lanez video where he disrespected her. And then Megan Thee Stallion, what was the whatever video? There was somebody who kind of looked a little bit like Megan. Hell, she literally showed up in Glasses Malone's video earlier this year. But she ain't reporting out here about Glasses Malone being on trial, then showing up in a nigga video. But people love to say that Megan Cuniff is so biased. We don't got no records of her receiving payment. She ain't going out to dinner with niggas. She ain't traveled from Houston to Miami to LA to go see niggas. She ain't in nobody text messages and emails sending evidence talking about this may be able to help you. But Milagro gets to do all of that and still call herself media? That's what they're pushing back on here. I wish they would have done so in court a little bit harder. Florida's pre-suit notice statute applies to members of the media that seek to inform and initiate uninhibited, robust, and wide open debate on public issues. The test is one of the function, not form. For instance, operating a blog commercially does not automatically confer media status. So just running a blog does not give you media status automatically. Just wanted to reiterate that for some people out there who may feel different. And although editorials can receive media defendant protection, such protections are conferred only to those that editorialize as to matters of public interest without being commissioned to do so by their clients, which they counter. She's been commissioned by Tory Lanez and his father, and there's multiple payments and incentives that she's received that say so. Courts have consistently refused to extend media defendant status to parties who disseminate information on behalf of clients or for personal financial gain. In Ortega Trujillo, the court held that a public relations firm registered as an agent of a foreign bank did not qualify as a media defendant despite having sent press releases to major South Florida media outlets. As the court found in that case, false, intentionally misleading, or defamatory publications have no essential part of the exposition of ideas and are of such slight social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interests in order and morality. I hate how that goddamn Trujillo shit just whooped my ass like that. I'm really stuck on goddamn Ortega Trujillo. Just whoop my ass like that. I don't like that. Here, defendant statements clearly do not benefit order and morality. In fact, the jury found unequivocally that the statements were defamatory, thus outside the ambit of protected speech under the First Amendment. Questions 1 and 2. Defendant's defamatory statements not only came at the great expense of plaintiff's emotional well-being and professional and personal relationships, but also by their very defamatory nature caused harm to the public. The deleterious impact of her words is all the more evident here, where defendant's statements sought to intimidate a key witness and crime victim and obstructed criminal legal proceedings. Likewise, defendant's use of disclaimers to inform her viewers that she should not be relied on for fact reporting cuts against her receiving media defendant protections. Okay, here they go into another case. The court emphasized that Florida law focuses on whether the defendant engages in the traditional function of the news media, which is to initiate uninhibited, robust, and wide open debate on public issues, not beneath self-proclaimed motivated commentary. Defendant falls squarely within the category of non-media defendants identified in Ortega Trujillo and Tektronic. Financially motivated advocacy. Financially motivated advocacy. Put that on a t-shirt. Like the public relations firm in Ortega Trujillo, that was commissioned by his client to disseminate information. Defendant admitted she was paid by Mr. Peterson's father, receiving $3,000 over 17 months for promotion services, and sought exclusive interviews that would change her life. Her quote: Milagro Cooper trial, November 18th, 2025. Milagro Cooper, she promised to keep conversations with Sunstar Peterson confidential, stating, "I appreciate you so much and will without a doubt keep my lips sealed." Defendant's September 2020 Instagram DM with Sunstar. We also have Milagro Cooper, November 18th, 2025. Her content was neither disinterested nor neutral. She acknowledged that Sunstar referenced me as a daughter and confirmed receiving paid travel accommodations for meetings with him in Miami. On the other hand, defendant claims to have never contacted plaintiff in an effort to conduct due diligence and a comprehensive investigation into the facts. Defendant admitting she has never met or contacted plaintiff. Like Bonilla in Tektronic, defendant's own words condemn her claim to media status. Oh, let me not smooth past Milagro admitting she never met or contacted Megan, right? Because typically, and we see this, we read articles on this channel quite often, probably daily. And one thing that you typically see at the end of most articles, especially if it's something controversial or it has to do with two parties, what they do is say, such and such has not responded to questions about this matter or something like that, right? So let's say Kendrick and let's look at UMG versus Drake, right? With all their legal proceedings. And a publication may reach out to Drake's legal team, and they also reach out to UMG's legal team, right? They're asking both parties for their perspective of what's going on, and then they come to report. Now, if one party decides not to answer, okay, we can only post what the party that answered stated. But we'll say we reached out for questioning, they didn't respond. That's what the journalists do. They check in with the sources and say, would you like to offer anything towards this? If you don't, hey, I can't quote you. You didn't speak to me. But here, it's pointed out that Milagro has never reached out to contact Megan, which also shows that she doesn't operate as media. She was only working for the Petersons. Like Bonilla and Tektronic, defendant's own words condemn her claim to media status. She stated definitively and contemporaneously that her commentary is not meant to be a news report, and I shouldn't be regarded as a news source any damn way. Her words on her own platform. I ain't gonna lie, they jam-packed these motherfucking 22 pages. When I saw 22 pages, I was like, we're gonna get through this quick. Man, they jam-packed this motherfucker. I thought it was gonna be like a 30-minute video. Fuck. Anyway, defendant supplied information to the Petersons in an effort to show that Daystar Peterson was innocent, then published information she received from them without any independent corroboration in order to sway public sentiment. Defendant's November 25th, 2022 email to Sunstar Peterson with alleged dirt on Miss P and attachments. This may be of value. Sunstar's texted defendant that he has breaking news concerning the detective investigating the shooting. November 18, 2025, admitting to sending Sunstar information to help Daystar's criminal defense. Acknowledging she spoke to Sunstar all the time, including the morning she published false DNA evidence. So she had literally talked to that nigga right before coming out and putting that shit out. And let's remember, that information was only supposed to be available to the parties at trial. It was sealed from public. She talked to his dad and then came to the internet with it. The jury's verdict confirms that they believe defendant acted on behalf of Mr. Peterson despite her testimony to the contrary. The jury was instructed that Miss Pete claims that Miss Cooper acted extremely and outrageously by coordinating with Mr. Daystar Peterson and others to distribute false statements about Miss Pete and to promote and distribute an altered sexual depiction of Miss Pete, which caused her severe emotional distress. That was read in the verdict. The court similarly instructed the jury that plaintiff sought punitive damages for conduct arising out of that coordination. The jury's verdict in favor of plaintiff on all counts and its award of punitive damages is unmistakably a factual finding by the jury of coordination between defendant and Mr. Peterson, and not just any coordination, but the kind that is so extreme and outrageous that it goes beyond all possible bounds of decency and is utterly intolerable in a civilized community. As the record reflects, defendant's so-called reporting was nothing more than the public relations arms of the Petersons. Her near singular focus was falsely discrediting plaintiff to advance Mr. Peterson's standing in and out of court. And when defendant was not acting as Mr. Peterson's mouthpiece, she was, as the jury found, inflicting intentional emotional distress and promoting a deep fake pornographic video of plaintiff. Defendant's conduct is so far afield of what constitutes a media defendant that no court has ever granted media defendant status in these circumstances. This court has already ruled twice that defendant is not a media defendant under Rule 770.01 Florida statute, and it should do so again now. Relief under Rule 59E and Rule 60B-6 is appropriate. Should the court disagree that the jury's verdict on defendant's media defendant status was advisory, that's such that the December 2nd, 2025 final judgment was also a final judgment on count 1, defamation per se, plaintiff requests relief from the final judgment under Federal Rule of Civil Procedure 60B-6, allowing relief from a final judgment or order for any other reason that justifies relief, in 59E, allowing motion to alter or amend a judgment. The circumstances here are extraordinary. The final judgment rests on a manifest legal error and results in manifest injustice. Not only did the court's final judgment revisit and reconsider the same legal question it had already decided in the motion to dismiss order, but it also relied on and permitted the jury to resolve legal classifications and standards reserved to the court. This appears to be the first case of its kind in which a jury decided as a matter of fact a defendant's qualification as a media defendant. The consequences are substantive, not merely technical. This combination of legal error and outcome determinative effect is exactly what Rules 59E and 60B-6 are designed to correct to prevent manifest injustice. As such, the court should alter or amend the judgment to reinstate the jury's verdict and enter final judgment consistent with that verdict. Conclusion. Wherefore, plaintiff respectfully requests that the court disregard or strike the media defendant interrogatory answers as immaterial, enter final judgment in plaintiff's favor on count 1, defamation per se, consistent with the jury's verdict, finding defendant liable, and enter such other relief the court deems just and proper. All right. So that's new filing from Megan Thee Stallion concerning the judgment from the trial. So she's saying that defamation need to come the fuck back. Y'all niggas tripping. We been established she wasn't a media defendant. She never needed no goddamn pre-suit notice about no damn, I'ma warn you to take these statements down or do whatever before I sue your ass, because you are not considered media. The judge reflected in the motion to dismiss order that she was not media. So why is it being said that she is media now? Again, unfortunately, her legal team should have fought harder at trial, especially as they continued to extend the trial beyond what people thought it would be. Now they got to try to find legal ramifications to say, hey, under the guidance of case law, this shouldn't have happened. What happens from here, I don't know. I'm not going to come out and say what I think should happen because I don't know what the fuck is supposed to happen. You know, they make very compelling arguments here, But how the judge is going to respond to it, I haven't the slightest. And I bet y'all, if she's not already, at some point, Milagro's going to come out and see, she's still obsessed with me. She trying to get motherfucking defamation overturned. Crazy motherfucker. Anyway, let me know what y'all think of all this down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider. I'm going to catch y'all on the next one, man. Happy holidays. Enjoy the time with your family, man. Do something productive. Just don't find yourself in no shit like this, all right? I'm going to see y'all later. Peace.
Yeah, family over fame in this bitch, yeah. The glory of living righteous is setting in. My street knowledge and education's a perfect blend. Young mogul, independent, I've been setting trends. The first one from my family to be faithfully wed. Fuck niggas and the horses that they riding on. I see this shit from all angles like a polygon. I'm never politicking, the drama be piling on. Father and great son acknowledged like I'm Bobby Bonds. Conversation with my lady about the paper route. 5-6 bank accounts, every day I make it count. They down talking my commentary for hating now. Well, I can take it cause I'm bodying your favorite now, please. I can do this shit in my sleep. I been writing for these niggas, y'all read it and weep. I been fighting these niggas if you speak on the street. I'll turn your birthday party into New Year's Eve. Don't let me take it there. We ain't playing fair. This the ATL, Southside nigga moving furniture like Wayfair. Life on hold, no insurance for your healthcare. Lifeline gone, so you wanna be a millionaire? Well, let me tell you about this world I built. The women I dodged, the niggas that